So what we're going to do is now hear from Christopher Carani, and we'll then start our coffee break, tea break a little bit later. So we will have 15 full minutes for questions following this presentation. So do start thinking about your questions so we can kick off quickly after Christopher finishes his presentation. But in the interest of time, are you ready to start now?
Let's jump in.
Wonderful. Let's go then.
Which button is the advance button?
Oh, that's a good question. Is this one? Is the
Okay. Sure.
on that?
All right, my name is Christopher Carani. I'm coming from the United States. I'm a intellectual property attorney with focus on litigation, specifically in the design rights area. We've heard a lot about accumulation, which was sort of the broader topic of today's discussion, but as you can see, it's sort of a broad umbrella and what it encompasses. We talk about accumulation with respect to rights between various jurisdictions. You can have types of cooperation type of agreements between countries. You have accumulation when you're talking about the various types of rights, various types of intellectual property rights. One of the issues that when I was thinking about this issue of accumulation is one that comes up with this idea of evergreening of intellectual property rights. You probably hear it most prevalent in the pharmaceutical realm, where you're talking about taking a particular pharmaceutical drug and extending the life of it beyond the term that was provided underneath patent protection. I want to talk a little bit about the expiration and what that means, because it enters, yesterday I think I heard the term public domain mentioned 12 times. And I want to challenge people as to what is the meaning of public domain. What exactly does that mean? And where does that information, are there any types of limits and metes and bounds placed upon that information? Coming from the US perspective, we have this notion of the right to copy doctrine that is laced throughout our jurisprudence. And with the system of stare decisis, there is some question as to whether or not the impact and implication of those statements. I want to give some various examples, some empirical study of evergreening. And then perhaps we're hearing today about some arguments saying that we should terminate rights and that they should indeed cease at the end of an intellectual property right. I want to provide the support and the rationale for concurrent and consecutive rights. And then lastly, because indeed this is about the future of design, I just would like to make a few comments on some insights and implications for the future. So like all great stories, this one begins at a time long ago in a place far, far away. And this is particularly Chicago, my hometown. When I was a child, I lived, was in an area with my three brothers where there was two golf courses, two private private golf courses. Our family didn't belong to these golf courses. We wouldn't be allowed to play on these golf courses. But my brothers and I were golf caddies. I don't know if you're familiar with a golf caddy, but basically you carry the bag for other members at the golf club. And I learned a lot on the golf course, and indeed this was how I ended up going to college. If you've ever seen the movie Caddyshack, where the young caddy's trying to earn a scholarship to go to college, my brothers and I earned what we call an Evans Scholarship, which is a golf caddy scholarship, which allowed you to go to college. So we would actually caddy at the course down here in the bottom portion of the screen, the private links down here. Now there was a public park that was located adjacent, and we used to go there. Indeed, there was a fishing hole where you could fish in this public park. It was free to ingress and egress the park anytime you wished. At a certain time, the private links, the other one, turned public. They lost money, and they ended up the city ended up buying the course. Now, we sort of loved this because all of a sudden there was, at least we had access to a golf course. There was somewhere where you could play. Now, my brothers and I, we would work at the private links. We would caddy. Sometimes we would wake up, 6 a.m., do 2 to 3 loops a day, and then we would take our money and we would go over to the clubhouse and we'd play the first hole at the golf course. Now, there was 3 of us, my 3 brothers, or 3 of us all together. And we had another friend who lived down the street, but he wasn't a really good caddy. He would wake up, 11 o'clock. He would never go to the caddy shack to actually get out there to work, but he loved to play golf also. So he wouldn't pay the fee to get on the golf course. He would join us on the second hole. There was a hole in the fence and he would access. So he never actually played the 18-hole course. He only played 17 holes of the course. Never played the first hole. So I recall one time we got onto the third hole, and sure enough, we were a little uneasy, my brothers and I, about having Danny join us on the second hole. When we got to the third hole, sure enough, I saw in the distance the ranger. In other words, this is sort of the police of the golf course coming our way. And he came over to my brothers and I and says, "Can I see your ticket?" And we dutifully showed our ticket and our badge that we had paid. And then he came over to our friend Danny and said, "Sir, where is your ticket?" And Danny, although he wasn't the sharpest guy, he cleverly replied, he says, "That's the private course. This is the public course, public for all to use, correct?" And the court ranger, the course ranger said, no. Even though it's public, there are still rules that apply. And he carted Danny off in the golf cart, and away they went. So this moment in time, I suppose, as I was contemplating this issue, made me think again once about what is the meaning of public. And when we talk about public, you hear throughout the scholarship, certainly. I know even reading Graham's article, you see notions of common property, public juris, domains of things public. You hear it as a negative right, the opposite of IP rights. You also hear all that which is not covered by a private right. So one of the things that happens here is once a patent expires, what happens? What happens to that monopoly? What happens to the knowledge that was set forth in the patent itself? Well, some would argue that it just rests in peace. That's done and that monopoly is over. And they say it enters the public domain. There are others then that continue on and say that that particular right that was set forth in those documents, there becomes an affirmative right to copy. In other words, this is part of the grand bargain with the public. When you get those rights, you then are allowed a right, an affirmative right to copy that information. And it's subject to no other IP rights. Now there are, in the United States, and I don't want to get too much into the case law. That's not the point of my presentation. I really want to get a little more into sort of just the policy behind, because it seems like we're all sort of struggling with this concept of accumulation of rights. There are a couple other U.S. Supreme Court cases, but I think this is sort of the boiling point here. 1945, so just at the end of World War II, we have this statement in the Supreme Court saying that the aim of the patent laws is that the members of the public shall be free to manufacture the product or employ the process disclosed by the expired patent. So free to manufacture, free to employ the process. And then it goes on and says, also the consuming public at large shall receive the benefits of the unrestricted exploitation of its disclosures. A very broad edict laid down by the court. So here we go. So you've got a dedication to the public, and then you move on and say it's an unrestricted exploitation. It's untouchable information. You can't use this. You can't appropriate it for any other reason. This is this idea of this bargain theory, this sort of quid pro quo. You have disclosed this information, and therefore now it's protected and it's available for all to use. Now, what is exactly, is this one of the critical questions to ask is what is disclosed? What actually is the quid pro quo? Well, we know when you file a utility patent application, you have your specification, you have to set forth sometimes what is the way indeed to practice the particular invention, often in excruciating detail. But what is the disclosure? Is it the claims? I mean, some might argue that that's the quid pro quo, right? I mean, I'm getting the limited monopoly not on everything that's set forth in the document, but on the specifics of the claims. That's what the monopoly that's being granted upon. You see people arguing that it's the elements of the claim. So it's the inventive aspect, the point of novelty. That is your contribution. Therefore, that is what the exchange is about. Then you even see broader than that. You say it's all information in the patent. I'm not making this up. I mean, this is the language from the case law itself, is that it's what's being disclosed and what's being exchanged and dedicated to the public is any particular descriptive matter appearing in the specification, the drawings, the claims of the expired patent, whether or not it's essential to the claim, invention or claim. Now, what is the impact of this when it comes to design? Well, let's take an example, okay? So with the utility patent, let's take the automobile, okay? So we've got an automobile claim. So what exactly is the disclosure? Is it everything that's set forth in there? Maybe they discuss the shape of the chair the seat. Maybe they discuss the shape of the wheel. Maybe they discuss the shape of the carriage. Maybe there's multiple embodiments in there. When that patent expires, is all of that dedicated to the public? Prohibited, untouchable information that cannot be reappropriated by any other intellectual property right? Querying. Now, what about the claim? Sometimes I think that maybe this is the narrower one and that the elements are broader and that the rest of the application is broader, but no, maybe it's the claim that's the broadest coverage, because as we know, and I use a car here, but just think this could be an MP3 player, this could be a smartphone, right? The claim could be on a smartphone for an aspect of it, but we know there are myriad designs, at least there should be myriad designs, of smartphones. But in this instance of an automobile, to fall within the scope of this claims, you have a body of a carriage, rotatable wheels, an engine, controllable means, but we know there are many, 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 many designs that can fall within the scope of that. But should the elimination or the expiration of the utility patent preclude any of these other particular IP rights? So let's play this out. So here's your utility patent on the car. Now you say, well, it was quite an advancement from the Tin Lizzie to go up to this Ferrari 435. But in any event, imagine that company later, through its design course, initially came up with the utility aspects of it, but then devised the trade dress right. What happens here? This is the critical point. Okay, this is the critical point. At that point, should those rights cease? Should they no longer continue? Is it rest in peace, or do they evergreen? Do they continue on? And particularly this one's sensational because we know that trade dress rights can extend in perpetuity. Or, now I said trade dress rights, but you know, most of us here are design lawyers or work in the field of design. So just as this one was trade dress rights, this was on, well, this could easily be swapped out for a design patent right. And to make the matter a little bit more complicated, well, you could have one design. I suppose you could have two designs. Let's maybe dollop on some copyright. Maybe there was something that was disclosed in the patent regarding some of the cloth or some of the aspects of the seating. And then let's even dollop on for good measure some trade dress. So we hear that this type of arrangement, we hear some of the pejoratives, euphemisms, evergreening, stockpiling. I like this one, life cycle management, line extension, all terms used to explain this type of practice of stacking IP rights. Now, I don't want to get into the case law here, and I think there's certain amounts of these cases where there are other confusing or issues that sort of cloud things. We talk about some of these cases. They're older cases where there's trademark generic issues that come into play. There's issues of functionality. Let's assume that the rights, these design rights, do not conflict with the functionality. Let's table that particular issue, and I think that's fair, and then all of a sudden we can get to the heart of the issue if we remove those from the equation. Because that's usually, a lot of times, the safety valve in the cases when people say, well, this later trade dress right you're getting, or this design right is really a functional aspect. Well, if that's the case, then those rights should never exist in the first place. That has nothing to do with any type of conflict with any other type of right. So here are some of the reasons why this whole idea of the right to copy is a fallacy. So when a patent expires, that limited monopoly is lifted. That's what happens. Those walls that were once around that particular right are lifted. The expiration does not equal an affirmative right to copy. Now, of course, you cannot extend the same exact right. So your utility patent, you cannot go out and take out another patent on that same utility patent. But it's not any type of right to copy that is the limiter. There are the other qualifications and prerequisites for that particular right. In other words, that idea has already been disclosed, therefore you're not going to satisfy novelty issues, inventive step, or obviousness issues. So the second one is that if you believe in those qualifications and the intended interests that are being served by that IP right, then each of these should be able to harmoniously coexist. So this chart here, again, I don't want to get into all the details, but it basically just lays out the US IP regime, and you probably can find the similar rights in each one of your respective jurisdictions, but you can see that you have utility patents, design patents, copyrights, trade dress. Each, when you're talking about the policy considerations, you're having a contribution to innovation, to knowledge, to progress. You have the policy of also rewarding the inventor. That's that sort of icon there with the man jumping on the pile of money. Utility patents, design patents, copyrights all have those similar type of things, but they also have the balance that's being struck between the requirements, the term, the protection, the test for infringement. It's a careful balance for each one of them, and they each stand on their own, and they're justified in their own right by each one of them. Now, down on the trade dress, there's different because we're actually, the interest is really the public interest with respect to the consumer. So what we can see in each one of these rights, as long as design one, as long as the interest that was intended with the metes and bounds of the balance being struck with the actual protections that are being provided is met, it can go forward. Similarly with design two, and that's why design two can be patented over design one. It's after a different subject matter subject to the particular interests that are at stake. Copyright, trade dress, they can all live in harmony. Now, when we talk about these particular issues, keep in mind too, it's rare that is the same particular right, okay? So when you're talking about even between a design patent might be underlying and a trade dress right, well, a trade dress can have many, many more aspects to it. There could be touch aspects of it, there could be color aspects, there could be shape, and there could be dimension aspects of it, things that you might not take into consideration in the design right. So there's really not a harmony between the two different rights that should be of any concern. So thirdly, the limiter of these things, again, is once something enters into the public domain, is that when you're going to look for that new IP right, whether it's in patents or in copyright, you have to have, be it novelty or originality, satisfy those. That's the limiter, not any type of affirmative right to copy. And this idea about the public domain, and we're sort of saying, well, Chris, this was dedicated to the public. Well, we routinely pluck from the public domain. A trademark, for instance, on the color pink, for instance, well, it's in the public domain, but we pluck it from the public domain, and it could be used so long as it satisfies secondary meaning, being that it's non-functional, and it satisfies the requirements for that particular IP right. Now, if it reaches the point where those interests are no longer satisfied, or they're violative of those rights, say it becomes generic, it will re-enter the stream of the galaxy of the public domain. Now, in this Singer case, which my colleagues who are proponents of this right to copy doctrine love to rely upon, it was the sewing machine case, and that was considered, the name Singer was considered generic, and that was one of the reasons why they didn't permit it. That entered into the public domain, re-entered the public domain. 60 years later, Singer, once again, the name became, it didn't violate the rules against genericness, and therefore they were entitled to get the name back Singer on a sewing machine. So we continually go in and out of the public domain so long as the particular interests at stake are being satisfied. So evergreening, when we talk about evergreening, it's sort of a pejorative, saying that you're sort of cheating the public, you're extending your rights beyond which was initially intended. Well, oftentimes it's not the same party. I mean, you could have an expired rights here on the automobile, but should that choke and should that cut off the entire industry of designing an automobile, which might fall within the scope of an expired design patent? No, I don't think that that's actually would be a good, because I think as long as the interests that are being served by your design statutes or by your copyright statutes are being served, there's no problem. Here you don't have this issue of any individual. This is a completely different party. So when we're talking about these accumulations, in short, in the US, to be clear, the majority view in the U.S. is that they are allowed, and make no mistake about that. There are these cases, these Supreme Court cases, which are out there, which talk about. I think that they each can be distinguished on their own rights, but I would point out that there is a critical juncture here, is that in between these cases, there is the 1946 Lanham Act, an act of Congress. So even if these other cases were to purport that you had this affirmative right to Congress, to right to copy, you have this intervening act. So this is, when we're talking in Europe, you're talking about all the different national laws. Well, there is an act here of where we are coalescing these rights into a federal law, which would apply across the land. And the last two cases, I mean, the most recent proclamation here is this Traffic's decision. Indeed, if there was a right to copy doctrine in Traffic's, if you recall, there was a utility patent on this sign that was on a spring, and the question was, could that right be extended with trade dress rights after the fact, after expiration? If there was a right to copy doctrine that the Supreme Court acknowledged, it would have been a one-page opinion. Okay, it would have been, there's an expired utility patent on this particular right, it's over. Well, it wasn't. Basically, they said that the trade dress rights were functional that were being asserted, and therefore were not valid trademark rights. So that's the resolution of my comment, but I look forward to further discussion on this issue of whether or not there is indeed a right to copy.